dear aspirants, welcome to Epitome IAS. So we are doing this UPSC PYQ analysis and we are doing the topic-wise PYQ analysis series. So today's topic would be the President, Vice President and the Governor from the Indian Polity. So let us start with the first question. So if you see here, the first question is, consider the following statements. Statement 1, if the election of the President of India is declared void by the Supreme Court of India, all acts done by him or her is in the performance of the duties of his or her office of the President before the date of decision became invalid. Statement 2, election for the post of the President of India can be postponed on the ground that some legislative assemblies have been dissolved and elections are yet to be take place. Statement 3, when a bill is presented to the President of India, the Constitution prescribes time limit within which he or she has to declare his or her assent. So if you see here in the first statement, what they are saying is, if the election of the President is declared void by the Supreme Court of India, then whatever act he has done during the office, it is declared invalid. So the thing is, no, this is not correct. Even if the post of President of India was declared void by the Supreme Court of India, those acts which he has done while in the position, while in the post, those are not considered invalid. They are still considered valid. So this particular statement would be a wrong statement. And if you see here, the second statement says that the election for the post of President of India can be postponed on the ground of some legislative assemblies have been dissolved and the elections are yet to take place. So if you see, even though some of the legislative assemblies, state legislative assemblies, they are dissolved or those elections are yet to take place, still the election for the post of President, it can't be postponed because this is one of the important posts, right? So they can't postpone the election of the President just because some of the state assemblies, they have been dissolved or some of the elections of the state assemblies are yet to take place. So this statement is also a wrong statement. And if you see statement 3, when a bill is presented to the President, the Constitution prescribes time limit within which he or she has to declare the assent. If you see, in the Indian Constitution, there is no provision, there is no prescribed time limit within which the President has to give assent or withhold the assent. Actually, if you see, the President has the liberty, he has indefinite time whether to give assent or withhold the assent of the bill, or also he can keep it aside and without reacting for indefinite period of time. So there is no time limit which is mentioned in the Constitution for giving assent to any particular bill. Okay. So this statement, if you see, when a bill is presented to the President of India, the Constitution prescribes the time limit within which he has to declare his or her assent. So this statement is also wrong. So if you see here, all the given 3 statements are wrong. So they are asking how many of the above statements are correct. So the answer would be B. None of the above are correct. So let us go to the next question. Consider the following statements in response of election to the President of India. Statement 1, the members nominated either House of the Parliament or the legislative assemblies of the states are also eligible to be included in the electoral college. Statement 2, higher the number of elective assembly seats, higher is the value of vote of each MLA of that state. Statement 3, the value of vote of each MLA of Madhya Pradesh is greater than that of Kerala. Statement 4, the value of vote of each MLA of Puducherry is higher than that of Arunachal Pradesh because the ratio of total population to total number of elective seats in Puducherry is greater as compared to Arunachal Pradesh. So if you see here in statement 1, what they are saying is the members nominated. They are talking about the nominated members of the either House of Parliament, that is the Lok Sabha and the Rajya Sabha. And they are talking about the nominated members of legislative assemblies of the states. So if you see here in the electoral college for the election of the president, we have the inclusion of elected members of parliament and we have elected members of state legislative assembly. Apart from this, we also have the elected members of the legislative assemblies of the union territories, that is of Delhi and Puducherry. So they are talking only about the elected members in all these cases. So the electoral college does not contain the nominated members of either the parliament or the state legislative assembly. So this particular statement is a wrong statement. And if you see here in the second statement, they have given that higher the number of elective assembly seats, higher is the value of the vote of each MLA of that seat. If you see the formula, there is a formula to calculate the value of the vote of each MLA. So what is that formula? So the value of the vote of each MLA is equal to population of that particular state. It should be divided by the number of seats of the MLAs. So if you see here, the value of each vote of an MLA is equal to the population of that particular state divided by the elected seats of the MLAs of that particular state. So what they have given here is the higher number of elective seats, then the higher number of value of vote of each MLA of that state. So if you see here in this formula, this value of MLA of value of each vote of MLA, it is actually inversely proportional to the elected seats of MLAs because it is in the denominator. So if this value, this particular value is higher, then the value of the MLA's vote would be lower. Let's say this particular value is lower, this particular value became higher. So they have kind of inversional proportional. But what they have given here is the higher the number of elected seats, the higher the number of value of MLA votes. No, this is not wrong. This is wrong. So this statement is wrong. And if you see the statement 3, that is the value of vote of each MLA of Madhya Pradesh is greater than that of Kerala. And if you see here again, the value of any particular state's MLA's vote can be calculated using this formula. That is, the population of that particular state should be divided by the elected seats of MLAs in that particular state. Even though Madhya Pradesh, it has more population than the Kerala. But when you divide the population by the elected seats of the MLA of Madhya Pradesh, the value will be lesser for Madhya Pradesh than the Kerala. So this statement is a wrong statement. And if you see statement 4, the value of vote of each MLA of Puducherry is higher than of Arunachal Pradesh because the ratio of total population to the total number of elective seats in Puducherry is greater as compared to Arunachal Pradesh. Yes, this is true. When you see, even though the population of Arunachal Pradesh is more than Puducherry, but what they are going to do? They are going to divide the population by the elected seats of the MLAs in that particular state. So when doing this, the ratio will become of Arunachal Pradesh, it would be lesser compared to the Puducherry. So this statement is the correct statement. So they are asking how many of the above statements are correct. So if you see here, only one of the statement is correct here. So the correct answer is A, only one. So here they have given the eligibility criteria. So for the eligibility criteria of a presidential office, he must be a citizen of India with at least 35 years of age. This is the first eligibility criteria. And if we see the electoral college of the president, that is, the president is elected by this particular electoral college, comprises of the elected members of both the houses, both parliament and the Lok Sabha, and the elected members of the state legislative assemblies. So here they are only talking about the elected members. They are not talking about the nominated members. Nominated members of both Lok Sabha and Rajya Sabha, they can't participate in the election process, and also the nominated members of the state legislative assembly, they can't take part in the election process of the president. Only the elected members of the parliament and the elected members of the state legislative assemblies of all the states, and also the union territories of Puducherry and Delhi elected MLAs, they will be taking part in the election. And if you see here, yes, this is the formula. That is the value of vote of MLA. Each MLA, his value is calculated by this particular formula. How? The total population of that particular state divided by number of elected members of that particular state legislative assembly into 1000. So if you see here, each state will be having a different value for this particular vote of MLA. So let us go to the next question. Which one of the following suggested that the governor should be an eminent person from outside the state and should be detached figure without intense political links, or should not have taken part in politics in the recent past? Statement A, First Administrative Reforms Commission 1966. Option B, Rajmannar Committee 1969. Option C, Sarkaria Commission 1983. Option D, National Commission to Review the Working of Constitution 2000. So if you see, this particular question is talking about the governor of any particular state. He should be outside of that particular state. He should belong to any other state other than that particular state. And he should not be involved in politics in the recent past. So this particular recommendation was recommended in the Sarkaria Commission of 1983. And if you see the other options, they are actually related to the center and state relations. Let us have a look. See here, the Sarkaria Commission, formerly known as the Commission on Center-State Relation. Yes, this particular Sarkaria Commission is also related to the center-state relation, and it was established in 1983. The primary objective of this particular commission was to examine the relationship between the central government and the state government in India. So it actually also talked about the governor, and it said the post of governor should be independent of this political things, and he should not belong to the particular state which he was appointed. He should belong to some other state. So this was said by the Sarkaria Commission. And if you see the other options, they have given that the First Administrative Reforms Commission, this was constituted in 1966. Again, this commission, its main, its main purpose of this commission is to address the administrative issues, and its focus was not specifically on center-state relations or governor selection. So we can eliminate this option. We actually eliminated that option. Then they have given about the Rajmannar Committee. So Rajmannar Committee, it was constituted in 1969. It was formed by the Tamil Nadu government under the leadership of Chief Minister Karunanidhi. And the primary objective of this particular committee was to examine and recommend measures for the improvement of center-state relations. And the next other option which they have given the question was the National Commission to review the working of the Constitution. This was constituted in the year 2000 and this commission was established much later compared to the other commissions. And even though this particular commission is also related to the center-state relations, but the Sarkaria Commission was the only important commission which talked about the governor's posting, governor's selection. So the correct answer was Sarkaria Commission. So the next question, with reference to the election of the President of India, consider the following statements. Statement 1, the value of the vote of each MLA varies from state to state. Statement 2, the value of the vote of MPs of Lok Sabha is more than the value of vote of MPs in Rajya Sabha. So the thing is, just now we were talking about in one of the previous questions, the value of vote of each MLA. The formula for calculating the value of vote of every MLA. What was that formula? That formula was value for vote of MLA, which is equal to the population of that particular state. It should be divided by the elected seats of MLAs of that particular state. So this is the formula to calculate the value of vote of each MLA. So in the first statement they have given that the value of vote of each MLA varies from state to state. Is that so? Yes, every state has a different value of vote for an MLA, because this, if you see this formula, the population of that particular state is divided by the elected seats of MLA. So every MLA value of each state would be different because the population and the number of elected seats are going to be different. So this particular statement is a correct statement. And if you see the second statement, the value of vote of MPs of Lok Sabha is more than that of value of votes of MPs in Rajya Sabha. So this statement is actually a wrong statement, because the value of MPs, irrespective of any house, even though he belonged to Lok Sabha or Rajya Sabha, it doesn't matter. Every value of each value of MPs, member of parliament, is equal. I'm saying that each value of each vote of MPs, member of parliament, are equal. There is no variation. Even though he belonged to Lok Sabha or Rajya Sabha, there is no difference. It is going to be same. Why? Because of the formula. So if you see here, the value of MP vote, how you calculate this particular value of an MP's vote? You have to first find out the sum of value of elected members of all states. They are not talking about any particular state. They are talking about the sum of value of elected members of all the states of legislative assemblies. It should be divided by sum of the elected members of both the houses of parliament. So if you see here, each MP's vote would be a equal value. There is no difference between different states or between the Lok Sabha and the Rajya Sabha. Every MP, every member of parliament is going to have the value equal. So let us go back to this question. This statement will be a wrong statement. So what is the correct answer? The answer would be A, only 1. So the next question, consider the following statements. Statement 1, no criminal proceedings shall be instituted against the governor of a state in any court during his term of office. Statement 2, the emoluments and the allowances of the governor of a state shall not be diminished during his term of office. So these are some of the basic facts which we usually read in the Constitution. So the first statement is saying that no criminal proceeding should be instituted against the governor during his term of office. Yes, this provision is given by the Constitution to the governor and to the president also to safeguard their space, to safeguard their term of office without any pressure from the government. They can actually work independently. To safeguard that, they have given this particular provision that no criminal proceedings should be done against the governor or the president. This statement is correct. Statement 2. The emoluments and the allowances of the governor shall not be diminished during his term of office. Yes, this is also true. Even for the president, this particular provision is there just to safeguard their post. So the correct answer would be option C, both 1 and 2. Next question. Which of the following are the discretionary powers given to the governor of a state? 1. Sending a report to the President of India for imposing the President rule. 2. Appointing the ministers. 3. Reserving certain bills passed by the state legislature for consideration of President of India. 4. Making the rules to conduct of business of the state government. So if you see here, they are asking about the discretionary powers of the governor. So if you see, all these given statements are powers of the governor, but they are asking about the discretionary powers of the governor. So if you see, in most of the cases, the governor, he can't act independently. He don't have that discretionary power. He has to follow the recommendations given by the Council of Ministers. But he also has some of the discretionary powers. Some discretionary powers are given directly by the Constitution of India. But there are some other discretionary powers which are not directly mentioned in the Constitution of India, but there are some indirect discretionary powers. But anyway, they are asking about the discretionary powers of the governor, not the non-discretionary powers. So we have to differentiate between those two. So if you see, sending a report to the President of India for imposing the President rule. Yes, this is one of the discretionary power. If let's say the state government is not functioning inconsistent with the constitution, it is going against the constitution. And let's say there is a breakdown of law and order in that particular state. Then the governor can recommend to the president that you can impose the president rule. So for taking this decision, it is his discretionary power. There is no need that he is going to ask permission from the Council of Ministers. So we can say this particular first statement is a discretionary power. Yes, that is right. Then statement 2, appointing of ministers. Is that so? Is it a discretionary power? If you see, the Constitution clearly mentions that the governor, he will be first appointing the majority party's head as the chief minister in a particular state. Then this chief minister will be mentioning some of the people of his own party or his own favor to appoint as the ministers, other ministers. Let's say the Council of Ministers. So these ministers are even though appointed by the governor, but it is not as a discretionary power. He can't appoint anyone on his own. It is not as discretionary power. He must appoint those people who are recommended by the chief minister. So this is not a discretionary power of appointing ministers. Even though it's power of governor, it's not a discretionary power. And if you see this third statement, reserving certain bills passed by the state legislature for consideration of the President of India. Is it a discretionary power? Yes. There are some bills which the state government has passed, but let's say the governor has a doubt that this particular bill is non-constitutional, unconstitutional. So the governor can reserve this particular bill to the president for his consideration. So whenever the state legislature, they pass a bill, the governor has some of the options. One is he can give a assent to the bill. Then the bill will become a law. The second option is he can withhold the particular bill. Third is he can send it for reconsideration. And the fourth is he can send it to the president. He can reserve it for the president to have a look when that particular bill is unconstitutional. So this is his discretionary power. Yes, this is a discretionary power of the governor. There is no need that the Council of Ministers should advise the governor to take this particular decision. He can take this decision on his own. So this is there. Then fourth statement, making the rules to conduct the business of the state government. So if you see here, making rules for the conduct of government's business, this particular provision is actually related to the Council of Ministers, because they are going to take the decision and they are going to recommend it to the governor, and the governor must follow the instructions given by the Council of Ministers. He can't take decision on his own. So this is not a discretionary power. Even though yes, this power is there with the governor, but this is not a discretionary power. He has to act in the way the Council of Ministers are going to recommend. So if you see here, the discretionary power, what are the discretionary power? The one, sending report to president for the imposition of president rule. Then reserving certain bills of state legislature to the president of India. So these two are the only discretionary power given here. So what is the correct answer? 1 and 3, option B is the correct answer. So if you see here, as I already told, there are two types of discretion. One is the constitutional discretion, which are directly mentioned in the Constitution of India. But there are also other discretions which are not directly mentioned in the Constitution of India, but they are seen indirectly. Okay, so let us see in detail what are these discretional powers which the governor has. So first, the constitutional discretion provided for the governor. The first one is the reservation of will for the president's consideration. This is directly mentioned in Article 200 of the Constitution. We just now saw this provision. Then, recommend for the implementation of President's rule. Again, this is mentioned in Article 356 of the Constitution. The government can recommend for the President's rule. And this is mentioned in Article 356. And next, while performing his duties as the administrator of a neighboring union territory. So let's say there is a governor of any particular state. Sometimes what happens, he'll be given an additional charge of taking care of any nearby union territory as well. So in that case, you can't go and tell he should follow the instructions given by the Council of Ministers of this state. As an administrator of another union territory, he can take decisions on his own. There is no necessity that this Council of Ministers of this particular state are going to say, take decision on our recommendation. No, that's not going to happen. So even though he is the governor of this particular state, the decisions regarding this particular state should be taken according to the Council of Ministers advice. But regarding another union territories decision, he can take the decisions by his discretion on his own. So this statement, this particular provision is also a constitutional discretion. Then, determining the amount payable to autonomous tribal district council as royalty from mineral exploration licenses by the governments of Assam, Meghalaya, Tripura and Mizoram. This is nothing but what? 6th schedule. So we have read this in the 6th schedule. It talks about the special administration of these tribal areas, especially in these 4 states. What are these states? Assam, Meghalaya, Tripura and Mizoram. So when there is some sort of mineral exploration is happening in this particular states, then the governor has a discretionary power on determining the amount payable to those autonomous district councils. He has that discretionary power. So this statement is there. Then, seeking information from the chief minister about the state administration and the legislative matters. Now the governor want to take some advice. He want to know some information about the administration or the legal matter of that particular state. So you can call the chief minister and ask for that information. So it is also his personal or discretional power. So if you see here, these are some of the situational discretion. So these situational discretions are not directly mentioned in the constitution, but due to some of the situations, these discretions are exercised by the governor. So what are these? Appointment to a chief minister when no party has a clear majority in the state legislative assembly, or when the current chief minister dies unexpectedly and there is no obvious successor. Yes, these are the two situations. Let's say in one case, when there is no clear majority, usually what happens, there is a clear majority and the leader of that particular party will be appointed as the chief minister by the governor. But sometimes what happens, there is no clear majority. Then what will happen? In that particular situation, the governor can act on his discretion and appoint a particular person as a chief minister. Then again that chief minister has to show the majority that is there. But that particular point, the decision to take which person to appoint as a chief minister, he has a situational discretion. And there is another case, that is, let's say there is a chief minister, but he suddenly died. Then there is no obvious successor. Most of the cases, if there is a successor, this person is going to become the chief minister and the majority people are supporting those particular person, no issues. But there is a confusion who is going to be the next successor. Then the governor has the discretion to appoint any person as the chief minister, and again after some time this person has to show the majority. But this decision he can take as a discretional power. Then dismissal of the council of ministers when it is unable to demonstrate the confidence of state legislative assembly. What it means? In state legislative assembly, let's say the no confidence motion has been passed. Then what happens? This person, this council of ministers, they have to resign. So this governor can dismiss the council of ministers when they are not able to show the confidence. When the no confidence motion has been passed, then the governor can dismiss the council of ministers. And the next thing is dismissal of state legislative assembly when the council of ministers lose their majority. Sometimes what happens, these council of ministers, they are not able to maintain the majority. In that case also, the governor has the discretionary power to dismiss the legislative assembly itself. So these are some of the situational discretionaries which are not directly mentioned in the constitution. So the next question, which one of the following statements is correct? Option A, in India, the same person cannot be appointed as governor for two or more states at the same time. Statement B, the judges of the High Court of the state in India are appointed by the governor of the state, just as the judges of Supreme Court are appointed by the president. Option C, no procedure has been laid down in the Constitution of India for the removal of a governor from his or his post. Option D, in case of a union territory having a legislative setup, the chief minister is appointed by the lieutenant governor on the basis of majority support. So if you see here, the first statement says that in India, same person cannot be appointed as a governor for one or more states, like two or more states. Is that so? No, that is not right. In India, a same governor can be appointed simultaneously to two or more states. That is there. So we can eliminate this option. Then the judges of the High Court of the states in India are appointed by the governor. Is that so? Just like the judges of the Supreme Court are appointed by the President of India, the judges of the High Courts are also appointed by the President of India. They are not appointed by the governor. So this particular statement is also wrong. And if you see statement C, no procedure has been laid down in the Constitution of India for the removal of governor. Is that so? Yes, there is no specific procedure which has been mentioned in the Constitution for the removal of the governor. They have just mentioned that the governor, he enjoys that particular post with the pleasure of the president. What it means? Which means the president can remove him whenever he wants. There is no procedure for removal of the governor. So this particular statement C, is a correct statement. And statement D, in case of union territory having a legislative setup, the chief minister is appointed by the lieutenant governor on the basis of majority support. If you see, this statement is kind of correct. But when we see most appropriate statement, that is option C. In case of D, what happens is the union territories which have the legislative assembly, they are not directly appointed by the governor. They are elected, right? They are elected, the legislative assembly, they are elected, and then they are appointed by the governor. It is not appointed directly by the governor. So this particular statement would be wrong in that sense. So correct answer is C. So next question, to the Constitution of India, it is the duty of the President of India to cause to be laid before the Parliament which of the following? 1. The recommendation of Union Finance Commission. 2. The report of Public Accounts Committee. 3. The report of Comptroller and Auditor General. 4. The report of National Commission for Scheduled Caste. So if you see here, the Constitution clearly mentions that the recommendation of the Finance Commission, it should be laid by the President. They are asking the cause to be laid. Yes, the President has to be the cause to be laid in the Parliament by the President. So this statement is correct. And if you see the report of Public Accounts Committee, no, there is no provision that the cause to be laid is the President. The Public Accounts Committee's reports are laid by the chairman of the Public Accounts Committee. So this statement is wrong. Then the report of Comptroller and Auditor General. Yes, this report is also to be laid by the cause of the President. The President has to be the cause to be laid in the Parliament. Then this is there. The report of the National Commission of Scheduled Caste. Yes, this is also there. Even though directly on behalf of the President, this particular report is going to be laid before the Parliament by the chairman of the National Commission of Scheduled Caste. But the cause to be laid is the President of India. So this statement is also there. So what is the correct answer? 1, 3, 4. That is C. C is the correct answer. So the next question. Who of the following shall cause every recommendation made by the Finance Commission to be laid before each house of the Parliament? President of India, Speaker of Lok Sabha, Prime Minister of India, Union Finance Minister. Just now we saw this thing, right? Who shall cause that the report of the Finance Commission, recommendation of the Finance Commission to be laid in the Parliament? It is the President of India. He should cause. Okay? He directly lays that particular recommendation in the Parliament. That is not the question. Who is the cause? Yes, this is by the President and it is directly mentioned in the Constitution of India. If you see here, yes, in Article 281 of the Constitution of India, it clearly mentions that Constitution clearly, explicitly states that the President shall cause every recommendation made by the Finance Commission to be laid before each house of the Parliament. So the next question, the following statements, the Governor of Punjab is concurrently the administrator of Chandigarh. Statement 2, the Governor of Kerala is concurrently the administrator of Lakshadweep. If you see, this question was asked in 2009. So based on that information, we should be answering this particular question. And what is the idea behind this particular question is, if you see, the Governor of Punjab, he is also the administrator of Chandigarh. And why? There is a reason. If you see the Chandigarh, it lies within the geographical area of the Punjab. even though Punjab is a particular different state, but Chandigarh is a UT, Union Territory, and the governor of Punjab is also the administrator of Chandigarh. Why? Because geographically, Chandigarh is inside the state of Punjab. So it will be easier for the administrative purposes. So that is the reason why the same governor is there for both Punjab and Chandigarh. But in case of second statement, they are talking about the governor of Kerala is concurrently the administrator of Lakshadweep. If you see here, Lakshadweep is one of a unique union territory. Apart from the administration, it has a diverse culture. Even the geographical, they are islands, right? So their geographical location and every part of it, everything is different from the mainland India. So it actually needs a separate administrator to administer those particular areas. So in this case, the governor of Lakshadweep, it is different from the governor of Kerala. They both have different governors. So this particular statement would be a wrong statement. So the correct answer is option A, only one. So that's all for today's class. Thank you, students. Let us see in the next class. We'll be discussing about the same topic. We'll be doing the part 2 of this particular topic, President, Vice President and Governor. Thank you.